Hello and welcome to this session in which we will discuss contract formation. What is a contract? Most likely you signed a contract before either to rental property or you purchase something. It's an agreement. That agreement is legally enforceable. What does it mean legally enforceable? When you enter into an agreement with another party, whatever that agreement happens to be, and you don't deliver, guess what? The other party can take you to court and enforce your compliance. So if not carried out, you have a remedy. The other person will have a remedy. There are three elements to the contracts. That's, you have to have an offer and acceptance. So someone is making an offer and the other party accepting the offer. We call the person or the party making the offer is the offerer and the acceptance is the offeree. Think about employer and employee. The employer offer you employment. As an employee, you would accept or you would reject. But you have to have that two-party offer and acceptance. Mutual consent, mutual assent, whatever you want to call it. Both parties are agreeing to something. You have to have an exchange of value. It doesn't have to be of equal value. So the two parties are exchanging two things, and it's a value. For example, a gift is not a contract because when the implication of a gift is you're giving something and you're not expecting anything in return. A contract will have an exchange of value. That value doesn't have to be equal and it doesn't have to be money. And we'll talk about equal values later on, monetary or some other value. And also for a contract, for a legal enforceable contract to exist, there should be no reason for the court not to enforce it. In other words, the contract is not illegal in one way or another. The elements of the contract we will cover in a separate recording. The reason I'm introducing them here to tell you what is a contract, elements of a contract, because in this session we are going to look at how contracts are formed. Now, although on this slide I have a picture where I have a contract and basically a written contract. The contract doesn't have to be written. It doesn't have to be written. We're going to see that shortly. Contracts can come in various forms, can be formed in various ways depending on how the agreement is expressed. You could have an expressed contract. You could have an implied-in-fact contract. You're going to have implied-in-law contract or quasi-contract. You can have a unilateral contract. And if you have unilateral, since we cover unilateral, we're going to cover bilateral contract. And this is what we will discuss in this session. In the following sessions, we would look at the elements of the contract. We're going to go ahead and start by looking at what is an express contract. Before we proceed any further, I have a public announcement about my company, FarhatLectures.com. Farhat Accounting Lectures is a supplemental educational tool that's going to help you with your CPA exam preparation as well as your accounting courses. My CPA material is aligned with your CPA review course such as Becker, Roger, Wiley, Gleam, Miles. My accounting courses are aligned with your accounting courses broken down by chapter and topics. My resources consist of lectures, multiple choice questions, true-false questions, as well as exercises. Go ahead, start your free trial today. What is an express contract? It's a contract formed by explicit language. Either that language is spoken or written. So notice, it does not have to be in writing. I can agree with you on the terms orally, and we have a contract. Now, if it's in writing, it's better, but it doesn't have to be. The terms are clearly stated and agreed upon by the parties, the offerer and the offeree, either verbally or in writing, okay? And you have here mutual agreement. Both parties must clearly agree to the same terms. This agreement is often evidenced by an offer from one party and acceptance by another. This clear communication distinguishes this type of contract from other type of contract that's as implied. See, express versus implied. What is implied? The meaning of it will form a contract or quasi-contract, which we will see next. Now, express contract, courts love them. Why? Because they are clear and ease in which they can be enforced. In other words, if you understand the agreement between both parties, the court can easily resolve the issue. An example will be if Tony promises to pay Paul $50 if Paul paints Tony's fence. So here, Tony and Paul getting an agreement. I want you to paint my fence, I'll pay you $50. That's the agreement. It's an express agreement. And it's a service agreement. Service means they are exchanging a service, not goods. And we're going to see later, in some circumstances, we're going to have to differentiate whether the item, the subject of the contract is a service or or goods. We'll talk about that later. So this is an express contract. Let's move from express to implied. An implied contract, implied in fact, there's an implied in law and implied in fact. It's formed through actions rather than words. Well, unlike an express contract where terms are clearly stated, this type of contract, implied in fact, is formed by the conduct or action of the parties involved. And the actions will indicate a mutual indication to enter into an agreement or mutual consent. So the mutual agreement is implied by the conduct, by the act. For example, if Emily goes to the hair salon, sits on the chair, and gets a haircut, even though without verbally agreeing on a price, there's an implied contract that Emily will pay for the service. There's a contract. Implied in fact contract are legally enforceable because, if you walked in, this is a hair salon, you sat in the chair and you got the service, you need to pay. So courts in this situation would look at the conduct of the parties to determine if a contract exists and what the terms are. For example, another simple example, shopping at a supermarket. You pick up an item from the shelves, you walk to the cashier, you give the item to the cashier, you pay, they let you leave with it. That's an implied contract. Maybe you don't even open your mouth or sign a contract. That's it. That's an implied contract by what? By the conduct. This is what implied in fact contract is. Then we have implied in law contract, or something called quasi-contract. So we have to know the difference. Implied in law contract, also known as the quasi-contract, is a legal concept created by the courts to prevent unjust enrichment, where there is no actual agreement between the two parties. So one party gets some sort of a service, but there was no agreement. But the party that received the service is, in quote, legally should pay. So what does that mean? Well, unlike an express or implied contract, the quasi-contract don't arise from a mutual agreement or intent to promise. There is no promise between the two parties. There is no agreement. Instead, they are imposed by law. So implied in law contract, implied in law, they are imposed by law to ensure fairness when one party benefits unfairly at the expense of the other. For example, if someone mistakenly receives services intended for someone else and benefit from them, a court can impose a quasi-contract to require them to pay for the service. Let's assume someone cut your lawn by mistake because they mistaken your address with another address. And let's assume you saw them, you didn't say anything. Well, guess what? You did receive a service mistakenly, and the company can force you to pay as long as the court find that was reasonable. This is what we mean by mistakenly received services intended for someone else. So it's implied by law, implied in law contract that you did receive the goods, the service, and now you need to pay for it. Another example will be, let's assume an unconscious person received emergency medical treatment and later billed for it. And that happened with me before. At some point, I had an accident, I was unconscious, they put me in an ambulance and they drove me to the hospital. They did not ask me whether I want to pay for the service or not. Well, although no contract was agreed upon because I was unconscious, a court can impose a quasi-contract requiring a payment to prevent unjust enrichment and ensure the hospital or the ambulance service, which was the ambulance service, is fairly compensated for its services. This is what's called implied in law contract. I cannot say, well, you didn't ask me, that was no contract was formed. Well, it's implied in law contract. We could also have unilateral contract. It's when one party makes a promise in exchange for a specific act by another party. In this contract, there's only one party that's legally bound to perform. So it's a one-sided promise. The contract involves a promise by one party, the offerer, in exchange by an act of another party, the offeree. The offerer is the only party with a legal obligation because the offeree will have to, if they want to be part of that deal, they'll have to act. So performance as an acceptance. The contract is accepted not through a promise. So if you're the person who's going to perform, you have to perform in order to accept. But the performance of the specific act is the actual acceptance. So what happened is this. Let's assume you saw a missing dog sign. Well, that's a unilateral contract. Someone promising, if you find my dog, I'll give you, a certain amount of money. Well, one-sided promise. To perform, you have to find the dog. You have to perform the act. The offeree is not legally bound to perform the act. The contract only becomes enforceable if and when the offeree decides to complete the request of the act, which is finding the dog. Now, the person that's making the offer can typically revoke the offer anytime before the offeree completes the act, as long as the offeree hasn't started performing the act or hasn't vested into the act. Common example will be of unilateral contract. Lost bets is a good one. Basically, you just, if you find my pet, I'll give you a certain amount of money. Or information leading to an arrest. Contest, a prize for the first person to complete a challenge. Those are what we call unilateral contract. One party making a promise, and there's no other party on the other side, except when they perform, they actually fulfill their requirement. We have unilateral, in contrast to bilateral, where the two parties each making a promise. For example, if Irene agrees to buy Jake's bicycle for $200 and Jake's agreed to sell it, both parties have exchanged promises, forming a bilateral contract. What else do we need to know about contract? Contracts are governed by two laws, either common law or the Uniform Commercial Code, which is UCC Article 2, Sales Article. So contract law in the United States is governed by two sources, the common law and the UCC Article 2, which is the sales contract. So you need to know what's common law versus UCC. Common law is a body of law derived from court decision rather than statutes. What statutes? Statutes are laws written in the books. It's the traditional law that's formulated over time through what we call precedents or judicial ruling. So basically, judicial ruling is determined by a judge. So if the judge decide on this case in the past in a similar way, future judges, they would say, well, based on the precedent, this is how I am going to make my decision. So this is what common law is. Common law plays a significant role in governing contracts that involve real estate, insurance, services, and employment. So anytime you have a problem, you have a multiple choice that's involved real estate, insurance, services, and employment, you have to refer to the common law. Now, why do we have to refer to the common law? Because in some circumstances, there might be some differences between common law and UCC. So that's why you have to know there are two sources for the contract law, either the common law or UCC. The common law covers real estate like land, insurance, services, and employment. The UCC, the sales article means articles means stuff, right? Sales article is a collection of legal standards and statutes designed to harmonize the law of sales and other commercial transactions across the US. It's like a book. Think of a book where it has all the rules in that book. The UCC sales article, Article 2. It's a statutory law versus common law, meaning it's written and enacted by legislative bodies. It's written in the law, Article 2 of the UCC, so you know the rule before you start your action, before you make a decision. The common law is based on a judge. What does that mean? If the judge changes their mind, this becomes common law. So usually the judges will follow the precedents. It means whatever, how the previous judge ruled, I'm going to rule. It's common law. But the new judge can change their mind. Versus UCC, that's the law. The law is already written. That's how it is. So the UCC, what we need to know specifically, it deals with contract of the sale of goods. Goods versus services. Goods are generally defined as movable items, items that you can touch, you can move, as opposed to real estate or services. Real estate, you cannot move a land, you cannot move a building, right? Those are unmovable. And services, you cannot touch. It's services. The UCC introduces several specific rules and principles that are unique to sales of goods, which we'll talk about later, distinguishing these transactions from those covered under common law. And that's why we have to know the difference between common law versus the UCC. And we're going to be discussing those later on a little bit more, much more specifically. Let's take a look at this multiple choice question from farhatlectures.com. Which of the following is an example of an express contract? A customer sitting in a barber's chair and the barber starts cutting their hair. I would say if you're sitting and you didn't say anything, I have to imply that you want to cut your hair. Therefore, this is not an express contract. Leo agrees to sell his car to Mia for $10,000 and Mia agrees to buy it. This looks like we have, direct communication, an offerer and an offeree. They're communicating what they wanted to do. I would say this could be an express contract. We'll hold on that. A person mistakenly received loan services due to an address mix-up. Well, this is not an express contract. You got the service. You might have to pay for it. It's implied-in-law. A doctor treats an unconscious patient in an emergency. That's also implied. because that person is unconscious, the doctor treated them, they expect compensation, and if not, they can say, well, it's implied in law that I want to receive the compensation. It's not express. There is no express here, no express agreement between the two parties. Therefore, as we expected, B is the correct answer. What should you do now? You want to go to Farhat Lectures, look at additional MCQs to reinforce what you just learned in this session. Whether you are studying for your CPA exam or taking a business law course, invest in yourself, invest in your career. The CPA exam is worth it. It's 20, 30 year investment in your career. Good luck, study hard, and of course, stay safe.